All right. Hi, everyone. My name is Jeff Lake. I'm an attorney in private practice in San Jose, California. I'm a member of the Bay Area Military Law Panel and chair of the Military Law Task Force of the National Lawyers Guild. So if you're a guild member, uh, please join the task force. If you're in the Bay Area, please help out the panel. And welcome, everyone. All right. So I'm talking tonight on the Insurrection Act. It's been in the news. It's been around for 250 years. So just wanted to trace the history, what it says, the problems with it, possible remedies, and where we go from here. I'd like to acknowledge the work of Joseph Nunn at the Brennan Center for Justice and Professor Stephen Vladeck of Georgetown Law School. This talk today is based largely on their scholarship, and I urge you to check it out if you want to know more. So starting at the beginning, from the beginning of the United States, there's been an aversion to using the military for policing. Over time, the British colonists began to chafe at the sight of British soldiers in the streets. This soon spread into entry into people's homes and even quartering there over the owner's objections. The Declaration of Independence charges the king with keeping among us in times of peace standing armies without the consent of our legislatures, affecting to render the military independent of and superior to the civil power, quartering a large body of armed troops among us and protecting them by a mock trial from punishment for any murders which they should commit on the inhabitants of these states. After the British were defeated, the new country soon adopted the Third, Fourth, and Fifth Amendments, which placed limits on the military's domestic operations that not even Congress can override. Following the Civil War, white supremacists in the South did not want the U.S. military enforcing civil rights laws. They helped pass the Posse Comitatus Act in 1878. The act is one sentence long and is at 18 U.S.C. 1385 and states, whoever, except in cases and under circumstances expressly authorized by the Constitution or Act of Congress, willfully uses any part of the Army, the Navy, the Marine Corps, the Air Force, or the Space Force as a posse comitatus or otherwise to execute the laws shall be fined under this title, or imprisoned not more than 2 years, or both. So the general rule is that the military is not supposed to be used for law enforcement. However, the military can be used for law enforcement when the use has been expressly authorized by Congress. And has Congress authorized it? The answer is yes, the Insurrection Act. So the Insurrection Act is a series of 5 statutes enacted by Congress in 1792, 1795, 1807, 1861, and 1871. Yes, I said 1792. As I said at the start, this issue of using the military to enforce the law was present at the founding, and Congress addressed it immediately after the ratification of the Constitution. According to the Constitution, Article 1, Section 8 empowers Congress to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. The Insurrection Act implements Congress's power under Article 1, Section 8. The Act is found at Chapter 13 of Title 10 of the United States Code, Sections 251 to 255. The Act authorizes the President to deploy the military for law enforcement purposes in 4 situations. 1, at the request of a state governor. Quote, whenever there is an insurrection in any state against its government, and the President considers it necessary to use the armed forces to suppress the insurrection. 2, without a specific state request, when the President considers that, quote, unlawful obstructions, combinations, or assemblages, or rebellion against the authority of the United States make it impracticable to enforce the laws of the United States by the ordinary course of judicial proceedings. 3, to put down any insurrection, domestic violence, unlawful combination, or conspiracy if it so hinders the execution of the laws of that state and of the United States within the state, that any part or class of its people is deprived of a right, privilege, immunity, or protection named in the Constitution and secured by law, and the constituted authorities of the state are unable, fail, or refuse to protect that right, privilege, or immunity, or to give that protection. And 4, to put down any insurrection, domestic violence, unlawful combination, or conspiracy if it opposes or obstructs the execution of the laws of the United States or impedes the course of justice under those laws. So this last situation uses incredibly broad language. The president can call in the military if she or he feels that demonstrators are obstructing the execution of the laws of the United States. We'll talk about problems with the Insurrection Act in a moment, but this is the most problematic of all, right? The act was first used by President George Washington to suppress the Whiskey Rebellion. The rebellion was sparked by a federal tax on whiskey, to which the farmers and drinkers of Western Pennsylvania took exception to by rioting. Washington scrupulously abided by the terms of the Insurrection Act statute. So what we have initially is congressional control through the act, Washington following it scrupulously, and U.S. Army historian called the greatest precedent for use of the military force in internal disturbances. However, since it went well, Congress took the wrong lessons and loosened the restrictions on the president authority to use the act. In 1871, as part of the Ku Klux Klan Act, Section 253 was added to the Insurrection Act, authorizing the use of the military to enforce federal rights, such as the right to vote. This section has not been substantively amended since it was passed. The Insurrection Act has been used sparingly, except for the Civil War, when President Lincoln proclaimed it on April 15, 1861, until its termination by President Andrew Johnson on August 20, 1866. Presidents Rutherford B. Hayes, Grover Cleveland, Woodrow Wilson, and Warren G. Harding deployed troops under the act to break strikes. President Grant used the act to suppress the Klan following the Civil War. President Cleveland twice used the act to attempt to protect Chinese immigrants in Washington Territory from violent white mobs who sought to expel them from the cities of Tacoma and Seattle and compel them to return to China. Finally, in the late 50s and early 60s, Presidents Eisenhower and Kennedy both invoked the Insurrection Act to enforce federal court orders to desegregate schools in the South. President Lyndon Johnson used it to provide protection for civil rights marchers in Selma, Alabama. The act has not been used to protect civil rights since then. There have been a total of 40 Insurrection Act proclamations in response to only 30 distinct crises. Not every invocation of the Insurrection Act has been followed by deployment of troops. Sometimes mere invocation calms the situation. The last invocation of the Insurrection Act was in 1992. This was in response to the uprising in Los Angeles following the verdict of acquittal in the trial of law enforcement officers accused of beating Rodney King following a traffic stop. In that situation, President George H.W. Bush sent troops at the request of California Governor Pete Wilson. The 34 years since is now the longest time in U.S. history without an invocation of the act. So what does invoking it do? One of the most important but least understood points about the Insurrection Act is that it includes no substantive authority. It doesn't authorize the military to use force. Rather, the Insurrection Act is merely an authorization to use federal armed forces to execute the existing laws of the Union, in circumstances in which no one disputes that those same laws may be enforced by local, state, or even civilian federal authorities. Even when the Insurrection Act has been validly invoked, as in Los Angeles, service members have no powers beyond what ordinary state, local, and federal law enforcement have. They can arrest and detain, but only if their civilian counterparts could do the same. The same criminal and immigration laws apply. The same constitutional rights attach as well. Invoking the Insurrection Act is not an end run around legal and constitutional rights. Indeed, this is the whole point of the Insurrection Act's law execution function, to use troops to help civilian authorities enforce the laws on the books. The purpose of the Insurrection Act is to supplement law enforcement, not supplant it. So finally, the Insurrection Act only permits the use of troops to enforce either federal law or a narrow category of state laws, essentially civil rights protections. Troops could not be used, for instance, to combat street crime, as that type of activity is governed by state and local laws. The Insurrection Act is not an exception to other federal laws that might apply to military conduct, such as the law criminalizing the presence of federal troops at polling places.
Sore after shoveling people.
So, what are the legal problems with the Insurrection Act? Well, getting back to the language of the Insurrection Act, it is archaic, confusing, and vague. Remember Section 252. The military can be used if, quote, unlawful obstructions, combinations, or assemblages make it impracticable to enforce the laws of the United States in any state by ordinary course of judicial proceedings. Anyone want to take a shot at explaining that? Obstruction, combination, and assemblage are not defined. What factors would render one of these unlawful? What level of interference or disruption would rise to the level of making it impracticable to enforce the laws? Or the language of 253. To put down any insurrection, domestic violence, unlawful combination, or conspiracy if it opposes or obstructs the execution of the laws of the United States or impedes the course of justice under those laws. It's unclear what's meant by unlawful combination. Similarly unclear what is encompassed in the term conspiracy and what would constitute opposing the execution of the laws or impeding the course of justice under those laws. It's not hard to imagine a president who sees a combination of people who oppose his or her policies as unlawful and obstructing the execution of the laws, thereby justifying calling in the military. In addition to the vagueness problems, the Insurrection Act gives extremely broad authority to the president to decide when to invoke the act. An early Supreme Court case from 1827 held that the authority to decide whether an exigency that triggers the act has arisen belongs exclusively to the president, and his decision is conclusive upon all other persons. This is still good law. Combined with the reluctance of courts to review decisions of the president when it comes to the military, and this Supreme Court's deference to this president, there's no way to successfully challenge invocation of the act. Congress is no help either. Congress has essentially delegated any role in suppressing insurrection or rebellion to the president. The president need not share with lawmakers the reasons for deployment or any plans for how the armed forces will be used. The law does not require any approval by Congress, report to Congress, or congressional oversight. So, what are the practical problems with invoking the Insurrection Act? Well, at the time of the Insurrection Act was put together, only about 15 cities had uniform police departments. Governors often called up state militias as reinforcements when there was local unrest. Today, there are well over 1 million full-time state and local police officers in the United States with a combined budget of $123 billion. New York City alone has 36,000 officers. There are more than 130,000 federal law enforcement officers. Police departments are equipped with modern military equipment and weapons, as we saw in Ferguson, Missouri. Policing has become more militarized with the institution of SWAT units and other military-like tactics. In short, it's hard to imagine a situation where the military itself is necessary when police departments have become so well-staffed and equipped so as to rival the military itself. A major problem with calling in the military to do policing is that service members are not trained to be police. Military personnel are trained and equipped to fight and destroy an enemy, one that does not have constitutional rights. They are accustomed to prioritizing force protection measures and responding to potential threats with overwhelming force. For example, when the Insurrection Act was invoked in Los Angeles in 1992, 7 Marines joined 2 local police officers as they responded to a domestic violence call. At the scene, as the police officers prepared to enter the home, someone inside fired a shotgun through the door. One of the officers shouted to the Marines, "Cover me," a request in law enforcement parlance that they raise their weapons and be ready to fire if necessary. But the Marines, in accordance with their own training, took it as a request for suppressing fire. They riddled the home with more than 200 bullets. Miraculously, no one was killed. As you can imagine, you can't just turn this training on and off, yet the Insurrection Act asked service members to do so. They did not sign up to be police officers. They're not trained as police officers, but they are being asked to be police officers. They're being asked to police a population, not to fight and subdue it. Using the military as police is a disservice to them and dangerous for the public. Theoretically, a service member could be prosecuted for misconduct or even murder, but we've seen how difficult those prosecutions are for actual police officers. Any such trial could resemble the mock trials complained of in the Declaration of Independence. In addition, use of the Insurrection Act when governors have not requested use of the military is a huge usurpation of state and local authority. As we have seen, the standards for invoking the act are incredibly vague. In these highly partisan times, a rogue president could simply invoke the act to punish a state for opposing his or her policies or to coerce it to act in ways the president prefers. There's a serious risk that unjustified invocations of the Insurrection Act would give the federal government power over local and state matters to agree that the Constitution's drafters could never have contemplated. Finally, domestic use of the military can be corrosive to the morale of the troops involved, who now have to be police officers, to the relationship between local and state governments and the federal government, and to the broader relationship between the military and civil society. As I said at the beginning, there's a long tradition of not using the military for policing. It is simply not the kind of society that a free people want to live in. So how can we fix it? As I discussed, the current version of the Insurrection Act is hopelessly vague and overbroad. Basically, it allows the president unlimited power to call up the military to suppress the civilian population. This power is not subject to oversight by Congress or review by the courts. So what could go wrong? Clearly, if the act is to remain, it needs to be clarified. One proposal suggests adding a statement of policy. Something like, it is the policy of the United States that domestic deployment of U.S. armed forces for the purposes set forth in this statute should be a last resort and should be ordered only if state authorities cannot or will not suppress the insurrection, rebellion, domestic violence, or obstruction of law at issue, and federal law enforcement authorities are unable to do so. If enacted, this policy would clarify the tradition of not using the military as law enforcement except as a last resort. Hopefully, it would deter a future president from using the military as an instrument of intimidation against states opposing his or her policies. Another proposal would clarify when the act could be invoked. Something like, the authorities provided by this act may be invoked in any of the following circumstances: insurrection or rebellion against government authority in such numbers and or with such force or capacity as to overwhelm civilian authorities. If the insurrection or rebellion is against a state or local government, the legislature of that state or the governor, if the legislature could not be convened, must request an invocation of the act. Other proposals call for spelling out what should not be authorized under the act. Stuff like not authorized, deployment of federal troops to suppress insurrection, rebellion, domestic violence, or obstruction of the law, except as expressly provided in an act of Congress. Or not authorized, lawless action. Military forces deployed under this act must act in accordance with all applicable federal and where not inconsistent with the United States Constitution or federal law, state law. Not authorized, suspension of habeas corpus. Not authorized, martial law. Military forces deployed under this act must act in support of and remain subordinate to civilian authorities. So you get the idea. The point is to remove the ambiguity from the statute and be as clear as possible about what is and isn't authorized. Also, it would return to Congress a role in any deployment of the military as stated in the Constitution. Finally, other proposals are for the president to issue a report upon invoking the act, detailing why it's necessary, and a description of the size, mission, scope, and expected duration of the use of armed forces. There's a proposal that Congress must act within 7 days, and each congressional authorization should only last for 14 days, pending another authorization. Another proposal would add that federal courts may review claims that the criteria for deployment set forth in the Insurrection Act were not met. So obviously these and other serious reform proposals are not going anywhere in this Congress and with this president for a moment. But there are those who recognize the problems that the current version of the Insurrection Act poses and have developed language that would ensure that any deployment of the military against civilians is done in rare emergencies and carried out with due care with the approval of Congress and judicial review. We will see if there is ever political will to take this on. I want to take a minute talking about the deployment of the National Guard. Last summer, we saw the deployment by the president of the National Guard to Los Angeles and the attempted deployment to other cities such as Portland and Chicago. These cities, of course, are not in favor of the immigration enforcement policies of this administration. Demonstrations occurred in all of them, voicing the people's opposition. In response, the president wanted to use the military to intimidate the demonstrators. However, for whatever reason, the president chose to call out the National Guard pursuant to a little-known statute, 10 U.S.C. 12406, subsection 3. He did not invoke the Insurrection Act. The statute allows the president to call in the National Guard, quote, whenever the president is unable with the regular forces to execute the laws of the United States. The president argued that these demonstrations were so out of control that local enforcement could not handle them effectively, and so National Guard assistance was necessary. Federal judges in all 3 cities disagreed, and after holding trials, issued injunctions against the deployments. This was based on the assumption that regular forces meant law enforcement, but that law enforcement was effectively executing the laws and the Guard was not needed. The cases made their way to the circuit courts, and eventually the Chicago case made it to the Supreme Court. During briefing, Professor Martin Letterman submitted an analysis of the statute based on historical accounts of its passage in 1908. He pointed out that the words regular forces referred to the military itself, not civilian law enforcement. In essence, the statute is a backstop for when both civilian and military force have failed, and the National Guard is the only force left before resorting to volunteers. This goes to our earlier discussion about the patchwork of policing that existed prior to the establishment of robust and militarized police forces of today. Professor Letterman argued that the statute relied on by the president requires the use and failure of the military forces at the president's command prior to the use of the National Guard. On December 23, 2025, the Supreme Court issued an unsigned opinion agreeing with Professor Letterman. The court held that the words regular forces in the statute likely refers to the regular forces of the United States military. The court concluded that before the president can federalize the Guard under Section 124063, he must likely have statutory or constitutional authority to execute the laws with the regular military and must be unable with those forces to perform that function. As we've seen under the Posse Comitatus Act, the military can't be used for law enforcement. Therefore, the president must have authority to use the military for that purpose. The obvious authority is the Insurrection Act, but he didn't invoke it. His arguments about inherent authority were swatted away. Therefore, he cannot use the National Guard as he was trying to do. This is sort of technical, but it fits in with everything I've been talking about. However, this president takes every opportunity to find a statute that gives him alleged unchecked authority and then pushes it to an extreme. He tried with this one, but ultimately failed. We'll see what comes next. So as I said earlier, the Insurrection Act hasn't been invoked since 1992 at the request of a state governor. Changes to the makeup of law enforcement have resulted in there being no emergencies where the use of the military would be contemplated until Trump. In May 2020, George Floyd was murdered by a police officer on the streets of Minneapolis. The murder was caught on cell phone video and broadcast worldwide on the internet. The result was demonstrations throughout the United States against police brutality. President Trump was furious. He ordered the military to come to Washington, D.C. On June 1, 2020, about 1,600 troops from Fort Bragg and Fort Drum began arriving in Washington. Also on that day, Army National Guard helicopters flew low over protesters, sending them running for cover and tearing posters from the sides of buildings. On June 7th, after widespread condemnation from military leaders, defense officials, and members of Congress, Trump complied with Washington Mayor Muriel Bowser's demand and ordered the National Guard to withdraw from Washington. On June 8th, 2020, the Military Law Task Force of the National Lawyers Guild issued the following statement. The Military Law Task Force of the National Lawyers Guild strongly condemns the use of the National Guard and active duty troops to police anti-racist protesters. The use of the military as a domestic police force is contrary to the United States Constitution, which places the military under civilian control, not the other way around. Military policing of civilian demonstrators who are protesting to urge their government to abolish racist police policies and tactics is a direct threat to the First Amendment rights of speech and assembly. The task force shares the concerns of organizations such as Veterans for Peace, Courage to Resist, and others that National Guard members may be given illegal orders or face real conflicts with their moral, political, or religious beliefs about deployment to violate the rights of protesters. We are concerned that Guard members are given almost no information about options available to them under military regulations to avoid or return early from deployment. We are troubled by the lack of effective legal alternatives for Guard members dealing with possible illegal orders and believe it is essential that members of the military are fully informed about their rights and responsibilities under the law. So, we've seen this president's desire to want to use the military for civilian law enforcement before, and we've spoken out about it. On his first day back, President Trump issued a presidential proclamation declaring a state of emergency at the southern border. The proclamation urged the Secretaries of Defense and Homeland Security to develop plans to police the border, including using the Insurrection Act. As we saw, Trump attempted to get around the Insurrection Act and send the National Guard to several cities. Using his special authority for the District of Columbia, he returned the National Guard to Washington, where it is expected to remain for all of this year. Most recently, we have seen large demonstrations in Minneapolis in reaction to the brutal tactics of ICE agents against civilians in that city. On January 15th, 2026, President Trump posted the following, quote, "If the corrupt politicians of Minnesota don't obey the law and stop the professional agitators and insurrectionists from attacking the patriots of ICE, who are only trying to do their job, I will institute the Insurrection Act, all caps, which many presidents have done before me, and quickly put an end to the travesty that is taking place in that once great state." On January 27th, Trump received a letter from the House Freedom Caucus urging him to use, quote, "all tools necessary, including the Insurrection Act, quote, to maintain order in the face of unlawful obstructions and assemblages that prevent the enforcement of the laws of the United States." Sound familiar? They left out the impracticable part. So obviously the president and his administration is well aware of the Insurrection Act. For whatever reason, he has not invoked it, despite being tempted to do so. As we have seen, there is really no impediment to doing so other than, as he put it, his own morality. Thus, the danger is real with this president who relishes nothing more than the exercise of absolute power. So, in conclusion, the Insurrection Act is a dangerous law that is subject to abuse by a rogue president. We have one now. The law is in serious need of major reform, something that is not likely to occur in this political climate. If it is abused by this administration and people are killed and or seriously wounded, the act may come under scrutiny as part of a post-mortem analysis exploring how this happened. In the meantime, if the act is invoked, it's important to remember that it is not a declaration of martial law. Such a term is not in the Constitution. It is not defined, and the president has no power to declare it. It is an invocation to the military to deploy against civilians in aid of local law enforcement. That means they are to act as police officers, not military combatants. As I pointed out, this new role as police is contrary to military training. In our role as attorneys and counselors, this is what we need to stress when asked by service members what to do. Called up to aid police, they will be in an impossible position of having to do a job they are not trained to do. In addition, there is the issue of illegal orders, which we pointed out in 2020 and continue to do so today. So the future, especially with this president, is hard to predict. I hope there is no invocation of the Insurrection Act. But if there is, I hope this talk was useful and you have a better understanding of this dangerous law.